Contentious probate is really disputes over wills or estates. So if somebody wants to challenge a will, possibly because they think somebody's been coerced into making it, or it wasn't executed properly, or they think the person who made it didn't have capacity, then they would be able to challenge that. Another reason to challenge a will might be if they have a claim under the Inheritance Act, where they can show that they were dependent on the deceased or a family member and should therefore have a claim on the estate. You can't challenge a will just because you don't like what is in there or because you didn't get as much as you thought you should have, because it's not about what you want. The usual rule is that if somebody makes a will, that we should stick to it unless there are grounds for disrupting that. So just because you don't get what you think you should have doesn't mean to say that you can challenge it. However, if you were dependent on that person, you might be able to make a claim under the Inheritance Act. Sometimes people can decide or choose not to leave a bequest to a family member, and it's usually sensible to have clear instructions as to why that might be. There's been a lot of news in the press recently about an important case in which a daughter who was estranged from her mother for 26 years made a claim under the Inheritance Act and managed to succeed. But each case is specific on its facts. And in that particular case, the mother had left the estate to 3 charities that she didn't really have much to do with, and there were reasons why they were estranged. So if you want to leave a family member out, you need to have clear instructions as to why, and then just give a lot of thought to what you want to do and whether or not that might be challenged.